This is the case of Tuason versus Court of Appeals with a GR number 116607. Private respondent Maria Victoria Tuason filed with the RTC a petition for annulment of declaration of nullity of her marriage to petitioner Emilio Tuason on the ground of psychological incapacity. After private respondent rested her case, the trial court scheduled the reception of petitioner's evidence, but the latter failed to appear at the scheduled hearings. On oral motion of private respondent, the court declared petitioner to have waived his right to present evidence and deemed the case submitted for decision on the basis of the evidence presented. The trial court rendered judgment declaring the marriage null and void ab initio on the ground of psychological incapacity on the part of the defendant. CA affirmed the order of the trial court. Petitioner cites the Family Code, which provides that in actions for annulment of marriage and legal separation, the prosecuting officer should intervene for the state because the law looks with disfavor upon haphazard declaration of annulment of marriages by default. He further contends that when he failed to appear at the scheduled hearings, the trial court should have ordered the prosecuting officer to intervene for the state and inquire as to the reason for his non-appearance as provided for in Articles 48 and 60 of the Family Code. Issue: whether the non-intervention of the prosecuting attorney is fatal to the validity of the proceedings in the trial court. The facts in the case at bar do not call for strict application of Articles 48 and 60 of the Family Code. For one, petitioner was not declared in default by the trial court for failure to answer. Petitioner filed his answer and actively participated in the proceedings by filing several pleadings and cross-examining the witnesses of the private respondent. It is clear then that in every stage of litigation was characterized by no-holds-barred contest and not by collusion. The role of the prosecuting attorney or fiscal in annulment of marriage and legal separation proceedings is to determine whether collusion exists between the parties and to take care that the evidence is not suppressed or fabricated. Petitioner's vehement opposition to the annulment proceedings negates the conclusions that collusion existed between the parties. There is no allegation by the petitioner that evidence was suppressed or fabricated by any of the parties. Under these circumstances, we are convinced that the non-intervention of the prosecuting attorney to assure lack of collusion between the contending parties is not fatal to the validity of the proceedings in the trial court.
Created using Powtoon.